When Virginia Giuffre accused the Duke of York of sexually assaulting her, the initial response of his London-based lawyers was to do nothing and hope the civil claim she had lodged at the district court in New York would simply go away. Or so it seemed. When that approach failed to impress, Prince Andrew called in a Los Angeles-based lawyer known for representing Hollywood luminaries accused of sexual misconduct. Andrew Brettler seems to take the view that the best form of defense is attack. He filed a 36-page court document at the end of October arguing that Giuffre's claim should be thrown out, in its entirety, without leave to amend. Failing that, says Brettler, Giuffre should be ordered to provide more details of her claim. The document is a memorandum of law in support of the defendant's motion to dismiss, or, in the alternative, for a more definite statement. It says Giuffre entered into a settlement with the sex offender and disgraced financier Jeffrey Epstein in 2009 which included a general release of all her claims against not just Epstein but others as well. To avoid being dragged into future legal disputes, Epstein negotiated for this broad release, insisting that it cover any and all persons who Giuffre identified as potential targets of future lawsuits, regardless of the merit, or lack thereof, to any such claims. Epstein's former attorney, Alan Dershowitz, and Prince Andrew are axiomatically among the releases in that 2009 settlement agreement. Indeed, that same agreement was the basis for Giuffre agreeing to dismiss her previously released battery claim against Professor Dershowitz earlier this year. Professor Dershowitz, as a third-party beneficiary of the 2009 settlement agreement, was entitled to rely upon and enforce the terms of that secret deal. Giuffre's baseless claims against Prince Andrew should be treated similarly and must be dismissed at this stage. Details of the settlement were redacted from the published version of the court document. These details appear to include the amount that Epstein paid Giuffre. In the memorandum, Prince Andrew's lawyers says he unequivocally denies Giuffre's false allegations against him. The Duke never sexually abused or assaulted Giuffre, it says in bold italics. Giuffre launched her baseless lawsuit against Prince Andrew to achieve another payday at his expense and at the expense of those closest to him. This sort of rhetoric makes good newspaper headlines, but it's not going to have much impact on Judge Lewis Kaplan, who is managing the case. He has given Giuffre's lawyers until the 29th of November to respond. The Duke's team then have until the 13th of December to reply. A hearing has been set for the 4th of January. What are the chances that Kaplan will dismiss the case at this stage? Brettler is relying heavily on the settlement reached with Epstein. He says that because Giuffre's allegations relate to a period before the settlement, the broad general release contained therein bars Giuffre's claims against Prince Andrew as a matter of law. The Duke was not named in the release agreement, but his lawyers argue that he was covered by its terms. That's because Giuffre's initial claim against Epstein alleged that, in addition to being continually exploited to satisfy Epstein's every sexual whim, Giuffre was also required to be sexually exploited by Epstein's adult male peers, including royalty, politicians, academicians, businessmen, and/or other professional and personal acquaintances, emphasis added. Brettler argues, under both Florida and New York law, Prince Andrew is a third-party beneficiary of the release agreement. Accordingly, he has standing to invoke the general release provision which forecloses Giuffre's claims as a matter of law. Will this work? Nobody can be sure, least of all Brettler. That's why he has come up with a fallback position. Giuffre was up against a deadline when she filed her claim on 9 August. New York legislation, the Child Victims Act 2019, had extended the limitation period for claims that would otherwise have been time-barred. But that extension expired just 5 days later. Prince Andrew's lawyers complain that, as the federal rules of civil procedure put it, Giuffre's claim is so vague or ambiguous that he cannot reasonably prepare a response. Giuffre does not allege what purported sexual contact occurred between her and Prince Andrew, when and where the incident occurred, or who threatened her, Epstein, his friend Ghislaine Maxwell, and/or Prince Andrew. It continues, to correct these deficiencies, the court should order Giuffre to provide a more definite statement of factual allegations regarding I. When and where the alleged New York incident occurred, e. What kind of physical contact she had with Prince Andrew, e. The facts demonstrating her lack of consent, including the nature of the implied or express threats and who made those threats to her and when, and IV. How Prince Andrew purportedly knew that she was a sex trafficking victim being forced to engage in sexual acts with him. Why should Prince Andrew be entitled to take advantage of a settlement when he is not named in it and has paid nothing towards it? Because, say his lawyers, that is what Giuffre agreed, and New York law enforces agreements of this sort. I'm sure her lawyers will take a different view. They were well aware of the settlement when they launched this claim. Is the Dershowitz case a precedent? Not really. Giuffre apparently agreed to drop her claim against Dershowitz when he relied on the agreement. But the agreement has never been tested in court. If Prince Andrew's lawyers were confident of success on this point, they would not have included their fallback position, that Giuffre should be ordered to provide full details of her claim. That application must be hard to resist. A shrewd lawyer would provide the required details ahead of the hearing on the 4th of January, so long as they exist. Just over a month earlier, on the 29th of November, Maxwell's criminal trial is due to begin. Lawyers on both sides of this claim will be looking out for evidence that may support their arguments. A full hearing of Giuffre's claim is planned for next autumn, unless the case is dismissed or settled in the meantime. I still think one of those alternatives is more likely than a public trial.